I'm Mark Nation of Morgan & Morgan, and I'm here to chat about business interruption, business income claims. And Ned, is the view okay at this point?
You're looking beautiful here.
All right, thanks so much. And I'm here in my home office and kind of dressed up, but the way we're handling today's webinar is exactly how we're doing court hearings now, through Zoom. And we appear in court just like this, and coat and tie, and have hearings. I've had, I guess, 4 so far substantive hearings this week on important issues for policyholders. And so I want to say welcome, and thanks for everybody coming aboard. First of all, I hope everybody's staying safe, and I know there is a lot going on with various business people and the losses that they've sustained and continue to sustain due to COVID-19. And I did want to talk a little bit about what we can do to help. And a little bit about myself. I've been practicing over 30 years. All I do day in and day out for 30 years is helping policyholders with claims, whether it's individuals or small businesses or large businesses. That is all I do. I don't dabble in other things. I do this day in and day out. I travel. Not only am located in Florida, but I'm barred. I have admitted to the bar in several states, and I practice throughout the United States helping policyholders, and that's what I do. I've handled hundreds and hundreds of business interruption claims over the last 30 years. This is nothing new to us. This is something maybe we can't anticipate a pandemic like this, but we certainly knew something like this could come, and how insurance policies are supposed to deal with these types of situations. And what I have on here with me, I think you can see several of my lawyers. And as a team in our insurance recovery group, we have 54 lawyers, and they're scattered throughout the United States. And I have a COVID-19 task force that I put together with some of my lawyers so that we can deal with these issues. But by no means are these all the lawyers that are working with us at Morgan & Morgan on this specific issue right now. And so I want to tell you, at the end of this, when we're done, you'll get an email. And that email is going to give you a little bit more information about us. But also, if you have questions, you can email us with the questions. And also, we have an AI tool. We call it Jimmy, the robot lawyer. And you can go on Jimmy. If you think you have a business interruption claim, then you can go on that tool, go through a couple of questions, and it'll qualify you for a claim if you're qualified. And we can move forward on your claim. That's the best way to get a hold of us regarding these claims, because as you imagine, there's so many of these being presented right now. The states that we practice in, that we are handling the cases in, Florida, Georgia, South Carolina, Mississippi, Texas, Kentucky, Pennsylvania, Tennessee, and New York. We have referral partners in other states that we don't have offices in, and we work hand in hand with them. Our partners in New Jersey, I spent hours yesterday working on a case with them, and we've got partners throughout the United States. So if your claim is elsewhere or your friends are, then we can probably help you when it comes to that. Don't hesitate to give us an email, and we'll put your friend or you in contact with lawyers in other states. And so I'm going to go through a few things, and then I'm going to open it up to questions and answers, and that's really going to be the best part. But I want to go through what we can do, a couple of insurance policy terms that you might want to look for, and then open it up for questions. And I can't imagine you're sitting there going, I don't want to hear about the terms. I want to hear about what you can do. I'll do that as I'm progressing through this. And at the end, we'll just open it up for questions and answers. So let me share my screen here first. That was the opening one when we started. And Ned, is that screen share effective?
Yes, sir.
All right, thank you. A word of caution, and that is, I mentioned at the beginning, this is all we do day in and day out is help policyholders, and I've been doing it a long time. There are a lot of lawyers who don't or have not had much experience in policyholder work, and they're starting to advertise and ask for these types of claims. And so if you talk to a lawyer and interview that lawyer, then I think you should ask some questions and be wise about it. Look at their website, see if it's something that they even have on their website, or if it's just a conglomeration of things. My insurance recovery group, again, 54 lawyers, it's all we do day in and day out. We do not dabble. This isn't part of what we do, it's what we do, it's who we are. And so let's move forward here on these screens. First things, and this is going to be one of the most important, a little bit of homework for you. If you called our office and hired us, we're happy to file a claim on your behalf. Whether you call us or not, I would recommend, if you have a business interruption claim, that you file a claim immediately. There's no problem filing a claim. You've got the losses, and you would then ask the insurance company, is it covered? And so this letter is all you would need to do. You date it, you send it to your insurance company, you put your name here, and you put the insurance company's name here, your name being your company name, or if you're a sole proprietor, your name or the company name. This is all you need to do to put them on notice of what type of claim it is. And then you simply say, I'm hereby presenting a claim for all coverages available under my business policy or policies. You don't need to sit there and go through the policy and try to figure out what coverages are or are not applicable. If you were to say, I'm submitting a business interruption claim, they might write you back and say, well, you don't have coverage for business interruption. But you do, and they won't tell you that you do have coverage for something called time elements or civil authority or some other type of coverage. So it's just better to say all coverage is available under the policy or policies, because you may have more than one, for this loss of income and extra expense. And the claim includes, but is not limited to, and you'll see the list of various things there that you can put. It's just important to get that notice to the insurance company as quick as possible. So far, every insurance company who has received, and that we've seen, received a letter like this or a letter similar to this reporting a claim, every insurance company so far has denied it, except in one small area of practice, and that is event cancellations. And you've heard about that. Wimbledon submitted a claim for event cancellation. Those types of claims, although they are being fought a lot, are being paid some. When this claim is submitted, whether you do it or we do it, and you get a denial, don't be intimidated. The denial might come with a long letter, 10, 15 pages, could be shorter. And people will read that letter and they'll say, well, I guess there's nothing that you could do. That would be a mistake. We're willing to look at your denial for free. If the insurance company did the right thing, we'll tell you that. If they didn't, we'll tell you that too, and what we can do to help you. I can only tell you this. Every single case I've ever won, they all started with no. They all have no in common. In fact, I can't win your case until the insurance company says no. So don't be intimidated by the no. Let us look at the denial for free. All right, go to the next page. One of the main questions I get is, what am I entitled to recover? Policies are different, but generally you're going to be entitled to these two types of expenses. Your normal continuing expenses that you're incurring right now, plus profit before taxes. And so that would be generally the business income portion. And I'm using that term loosely because it can mean different things in different contexts. And then the second thing is extra expenses incurred because of the suspension of your operation. Let's say you've had to hire somebody to watch something, or you had to haul some things away, or you've incurred any type of innumerable extra expenses because your operations were suspended. Those are the two general types of damages that you're entitled to. Now, this is the first lawsuit that we filed, and it was filed yesterday. We've collected a lot of them, and this one is for a dental office. I'm going to give you some examples of the people we're helping so you'll have an understanding of that. This is a dental office who does cosmetic surgery and is not allowed to do those at this point. They're not considered an essential business, and so they've suffered a significant loss of revenues. This is for a brewery. That first one was in Florida. This one is in Kentucky. We're filing another one right now in Pennsylvania. In addition, I've got a Pilates studios that has a number of studios, and they've all been shut down, as well as gymnasiums, restaurants, and all types of professional offices who've suffered a loss. Those are just an example of the type of clients that we have. And regardless of your business, if you're suffering a business income loss, we'd like to look at that claim for you. Now, what coverages are you entitled to generally? And I'm not going to get in the weeds on these coverages, but people are surprised when they find out their business interruption or business income claim originates in their property coverage. It's just a fluke, and it's a way it arose over decades that this type of coverage was put into your property coverage, the same coverage that's there if it burns down. And so in that policy, typically you're going to have your business income policy. It may be called business interruption. It may be called time element. It may be called a number of different things. You don't need to be digging through your policy. We will do that for you. We know where to look, and importantly, in each one of our states, we know what the courts say about how they interpret certain clauses. But I just want to show you some of the coverages. Here's just your business income coverage, and it defines it. Then we have the extra expense coverage. That's what we talked about. In addition to that, this is the next page of this same endorsement. We have civil authority coverage. This is when the government shuts down certain areas and people are no longer able to get to or utilize your business. All of these coverages are implicated because of COVID-19. And I can tell you what the insurance company is, what they're going to say is that there is no coverage under your policy. And 99% of the time, they're going to say it's because there's been no physical loss to your property. No physical loss to your property. Now, the thing that they're not telling you, and they may quote it just like that, is that's not the trigger for coverage. The trigger for coverage typically is going to be physical loss of or damage to the insured property, or if it's a civil authority coverage, it's physical loss of or damage to another property not insured under the policy. Physical loss of or damage, those are two different things. You can have a physical loss. If somebody steals your car, you've got a physical loss. It's not damaged at all. If you have a business that no longer functions as a business, that property no longer functions as a business, that is a physical loss with no damage to it. That triggers coverage. The insurance company is ignoring that issue. They ignore the fact that they distinguish between damage and physical loss. When you're shut down and you can't use your business as a business, it no longer functions as the property no longer functions for its intended purpose as a business. That is a physical loss. They're ignoring that. Let's continue. There's another source of coverage. They're ignoring that. It is not coming up anywhere in any of the letters saying, hey, we've evaluated that. And that's here. This says, we will not pay for loss or damage caused by or resulting from any of the following. But, and that's an important but, if loss or damage, here you see it again, they distinguish between the two. Loss or damage by a covered cause of loss results, we will pay for resulting damage, loss or damage. And what is one of those things that they promise that they're going to pay for? Government acts. An act or a decision or failure to act or decide of any person, group, or governmental entity. Well, most everybody's business is shut down just because of that. And this policy says that is exactly the type of thing that this policy was intended to pay for. Now, let's talk about the exclusions. Everybody has heard about the virus exclusion, I will promise you, there is not a single thing and one identifiable thing that is the virus exclusion. There are lots of different types of exclusions, some of which have nothing to do with virus that the insurance companies are trying to use. And then there are others that are have the word virus in it, but they also they're not triggered because of this type of loss. But I want to make this point first. Many policies do not have anything remotely like a virus exclusion. Many policies don't have that type of exclusion. And so we don't need to worry about it in a lot of cases. I'm going to go over a couple of them. I'll be quick just so you can see. If you happen to get a letter, see that there are ways around it. But a little background. So we had SARS in 2003. At that point, the insurance companies looked at that and said, that could be a problem in 2003. And then they began working on it. And with ISO, Insurance Service Offices, they're a vendor for insurance companies. And they came out with a new endorsement for virus. Virus is included. And this was July of 2006. And in their introduction, they did talk about SARS, a virus, a type of COVID virus. And then they wrote this exclusion. This exclusion is not in every policy. And some policies have no exclusion, some have a form of exclusion that has the word virus in it, and some have something like this. So this is the one they wrote in 2006. Immediately, companies like Lloyd's adopted this in 2006, but this one has gone by the wayside for the most part. It may be in some policies, but most of them, if they have this type of exclusion, is going to have the 2007 version. And I will just briefly show you. This exclusion, the exclusion set forth in B, applies to all coverage in Section 1 property. This includes, but is not limited to, forms and endorsements that cover property damage to buildings, and forms and endorsements that cover business income extra expense. It seems pretty strong. And if your insurance company sends that to you, let us look at it. I will point out one thing. Again, the trigger for coverage is direct physical loss of or damage to property for this one. And what does this particular exclusion apply to? Damage. It applies to damage to buildings or property. It does not say it applies to loss. And if this A isn't triggered, B never comes into existence. And so they've got to show, and the burden of proof is on the insurance company to show property damage. That's not even our claim. Our claim is not that there's property damage. Ours is that there's direct physical loss as a result of COVID-19, or more accurately, as a result of closures. That wasn't intended for this type of exclusion. Here's another one. Insurance companies might try to use this one. It's called a microorganism exclusion. It does not have the word virus anywhere in it. If they intended to exclude viruses, they would have been required to say so. The courts throughout the United States say these types of exclusions must be interpreted narrowly for the benefit of the insured. Something like this, I am strongly confident, is not going to apply to virus, but the insurance company is going to try to use it and say that it does. And a virus is not a microorganism. And we're almost done. Here's another example. This is a limited bacteria or virus coverage. And coverage has to be interpreted broadly. Coverage is interpreted broadly, limits narrowly. So let's see what this one says. All right, this one goes through, and it is talking about, let's see. Let me look at the next page. I'll make it a little bit clearer when they get here. I'll get to that one. It's only talking about when you have direct physical damage to property. Because they're telling you, we're going to provide you this coverage as long as you save and preserve the property from further damage. That's talking about mold or a virus or bacteria on the property itself. That's not what we're here about at all. This is nationwide, and that's contained in this section of the policy. And in this one, however, the exclusion does not apply to damage from fungi, any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress. This is one that we're working through right now. There is not a court yet that has ruled on this one. If your insurance company sends this one to you, let us look at it. Courts in various states are going to interpret these differently. I can tell you there are going to be some exclusions, some of the virus exclusions that the courts are going to follow, but it needs to be tested in court. Don't take it lying down. Final thing, and I've been getting this question a lot. Paycheck Protection Program, if I got money through that, PPP, do I have to pay that back? And it's going to depend on the state, and it's going to depend on the law in that state. I will give you an example. In Florida, there is no offset for payments like this if there is, by the people who give the money, a right of recovery. So if there's a right of recovery, then there is no offset. And it doesn't matter if the people who gave the money or provided the benefit exercise that right, or that the law would say that that right may be forgiven under certain circumstances. If there's a right of recovery, there is no offset. Other states don't allow these types of collateral sources at all to be utilized by insurance companies to reduce what they owe. And so that is all I have, and I'm excited to answer questions. Let's see what we got here. All right. Hey, Ned, do we have, and what you can do is put your hand up, if you know how to do that, on your more, the little more button. And I've got a bunch of questions. I'm looking at my chat box right now.
Yeah, there's a question from the audience here, Mark. The initial letter you showed in this presentation, do you file this letter to your insurance agent or go directly with insurance company?
I would recommend sending it to the insurance company with a copy to your agent. The problem with only sending it to the agent is, and we've seen this routinely, is the agent sometimes just holds on to it and says, hey, it's not covered, or they tell you it's not covered. And that may be somebody you've developed a relationship with, there's a trust there, but the agent isn't the one who litigates these things. That's us. And so don't just give it to the agent. It could get shut down. Send it to the insurance company. You can give a copy to your agent. What else do we got?
We have a question from Nancy. Nancy, I'm going to unmute you.
Thank you. I got a letter from my insurance companies asking me to answer 2 questions. Are you claiming direct physical damage or loss due to uncovered real property? And the second question is, are you claiming loss of business income at your covered premises due to direct physical damage or loss of physical caused by COVID-19?
So here's what they're getting at is, and what state are you in?
Florida.
Okay. What they want you to do is answer that on your own, and then they're going to try to shove that down your throat later. So I'll give you some guidance on how to answer it, but I would prefer that you have a lawyer who handles these types of cases answer it for you. The first thing I would tell you is the answer ought to say, please come in or investigate this claim, putting the onus back on them. I don't understand what those terms mean. You can say that. Please help me. My business, what type of business is it?
Restaurant.
Right. As you know, my business is not able to operate. Or are you closed, or it's just a slow down? How are you handling that?
We close.
Okay. My business is closed because of COVID-19. Did you have any employees that were actually, do you know, had coronavirus and were working in your establishment at that time?
Actually, I got really sick, and I closed, and I stayed sick for weeks, and finally they found that I have pneumonia, and I've been treated by pneumonia right now.
So the reason I'm asking that is for our clients who have had an employee or owner who's diagnosed with COVID, we do put that in the letter and say, to answer it and say they were there in the premises, and as you know, it can cause direct physical loss and damage. The virus itself, direct physical loss and damage to the property. And that way we would put the onus back on the insurance company. So I would like to sit down and write out the letter, wordsmith it, and send them that letter back. Because they're trying to get you to admit that there is no direct physical loss or damage. The direct physical loss, as I explained, is the loss of use of the building for its intended purposes. But I mean, if you can write that, that's fine. Or if you want us to do that,
No, I would prefer if you could help me out with that. That's why I joined the meeting today. So I'll stay here, and maybe you guys can take my phone after the call.
Well, you'll get an email right after the webinar, and just email back, and then we'll be able to contact you. That'll be the best way.
Okay. Thank you so much.
Thanks, Nancy.
Good question. What else do we have, Nancy?
Next up, we have a question from Jacob. I'm unmuting you, Jacob.
Hey, Jacob,
Hi.
how are you?
I'm well, thank you. I hope everyone on the call is well, and thank you very much for hosting this. So our company owns commercial shopping centers, retail commercial shopping centers, and in non-COVID situations on an annual basis, when we see hurricanes and sometimes local power stations fail or the parking lots flood or our building is affected, and we do have a covered loss. That's kind of like a hole that we're trying to fit ourselves into in this discussion. But in the ordinary sense, when we have a covered loss and we look to, as a landlord, to our rent loss coverage, or that's, I guess that's somewhat analogous to a tenant's business interruption insurance, our rent loss coverage will pay a claim if in our leases it says with the tenant that, hey, in the event of a casualty and you can operate your business, your rent is abated. If our lease says that your rent is abated in whole or in part, then we have a claim and our insurance company would potentially pay. But if our lease doesn't grant an abatement and says, no matter what, you have to pay your rent, then we don't have a claim. So that's what we see in a normal case, typically. In this scenario with COVID, we're trying to see if the same kind of analogy would occur, except here tenants are proactively reaching out to us saying, grant me a deferral or grant me a rent abatement. So if we agree with a tenant now, you know, we've heard from our insurance company, go pound sand, and we agree with tenants, look, we're going to grant you a deferral. We're going to not take your April rent or your May rent, your June rent, you pay that back next year or whenever. Would that still rise? Like, would we be precluded potentially? Should we slow down our approach to settling, you know, to making our tenants' lives easier, and slow down and better analyze whether deferrals or abatements would lend themselves better to a claim if we do have a claim under our insurance? So thank you. That's my question. I hope it was clear. I'm not an insurance expert, but hopefully tried to kind of communicate what it was, and hopefully that was clear. Thank you.
It was crystal clear, but stay unmuted because I will have a couple questions. Do your leases all allow for them to have a rent abatement in the event of a casualty?
It varies on a case-by-case basis. You know, national tenants will negotiate certain things and locals others, and our own internal philosophy about it has changed, where normally we would say, look, pay your rent no matter what in the lease. That might work for tenants with deep pockets, but your local mom and pop tenant, doesn't matter what it says, they don't have the funds to pay. So the strategy of saying, look, we're just going to look to our tenants and their leases say they got to pay, today we see that is not panning out in community neighborhood centers where you do have a few national anchors who are maybe open and flourishing, but most of the tenants are closed due to governmental orders closing their business, making their premises not usable. So it varies on a case-by-case basis.
Understood. So there are three issues that I want to talk about that I think will get us to where you need to go. First is we would look at the policy and see what the trigger is. I suspect the trigger for your coverage is going to be what I said, direct physical loss of or damage to the insured premises. And you've got direct physical loss. That trigger is there. People can't use those, the operations. It no longer functions as a shopping center because they're not shopping. Your tenants have closed. That is your direct physical loss trigger. Step one, because nothing matters if you don't trigger the coverage. Step two, is there an exclusion in the policy that would eliminate the coverage? I got to look at the policy and we'll see. Even if it has something that they say is a virus exclusion, I'd want to take a look at that. Anyway, third issue is, all right, you've got coverage, there's no exclusion, then what is the calculation of your damages? And then that becomes the issue really that your question is focused on. What is the calculation of your damages? People, I once had a fellow owed me some money and I said, are you going to pay? And he said, Mr. Nation, you can't get blood out of a tulip. And I looked at him, I said, you mean turnip? And he goes, it don't matter. You ain't getting no money. And so your tenants don't have the money. You have suffered a loss. Whether you're being nice and telling them you don't have to pay or not, really doesn't matter. they ain't paying. And so you've suffered a loss. Now, the question is, if later they catch up and your insurance company pays, can you make a double recovery? This comes up sometimes. People's car gets stolen and then 6 months later they get their car back. What happens? Depends on the policy language. Same with you. If your tenant catches up, do you have to give the money back to the insurance company? I don't know. I'd have to see the policy. But going back to, go ahead.
No, I was going to say thank you. Thank you.
But going back to your other question, sometimes the insurance companies tell you, hey, if you have this rent abatement thing in there, then we'll pay you, but if you won't pay. That might not even be in the policy. They may just be saying that, and you just go along with it. I don't know that that's accurate, what they're saying in the policy. So all that to say.
Yeah, thank you very much. We'll digest what the rest of the dialogue and discussion is. And, you've raised a lot of points. I've already requested from our risk management department because they've just told me, no, we don't have coverage. But this isn't the first similar webinar that's raised questions. And so I've already requested a copy of the actual policy and the exclusions just to see for myself. And then just as a final thought, I'll let the floor go. But in addition to rent abatements, often these leases complicate things further by saying that the abatement is secondary. The primary source during these issues will be the tenant's business interruption insurance. And once it's exhausted, if they may have 6 months of coverage, 12 months of coverage, whatever. Once it's exhausted, then the abatement kicks in. So that may complicate the refund issue you just mentioned, may complicate the timing of the payment of claims, and may magnify exponentially the number of claims necessary to get to a result.
Correct, but the insurance company doesn't get off the hook by saying, well, something good might happen to our insured later, so we don't have to pay. And so I'll leave you with this thought. One thing you may want to do is have your tenants forward the email to them so they can go on to our AI tool and see if they have a claim also. If they do, obviously that benefits you, assuming that they cut the check to you, or if you're listed as an additional insured under the tenant's policy.
We would be. We always are, typically. And now we've outsourced all of our insurance management to companies that are very robust at making sure these certificates, now more than ever, it's important to have them updated at your fingertips. So thank you for your insight and for all the information, and thank you to the group for everyone else's questions as well. Thank you.
Happily. Thanks for attending. What else we got, Ned?
So we have a question from Jason Moore. I'm going to unmute you, Jason.
Hey, Jason, how are you?
Hey, Mr. Nation, good. Thank you for doing this. I'm an attorney in Missouri and Kansas, and I'm seeing some of these cases filed as class actions, and I've also heard some chatter about an MDL.
Correct.
Can you talk about that? What are the chances of it getting thrown into a class, and do you think this would work in an MDL format?
Excellent question, and I've spent a lot of time discussing it and thinking about it, because we do have a department and we could do that. We do a lot of MDLs and class cases. However, when I think about these types of cases, let's say we've got hundreds of insurance companies that each write a little bit different policy. And then we've also got individual companies who might write 4 or 5 different coverages under different names. And then we have insurers who buy a whole lot of different endorsements. And so there's going to be a lot of dissimilarity between the policies that are written, the coverages and endorsements that are purchased, and then we throw on it this complication. Bottom line up front, I don't think the MDL or class is the best way to go for this. And for folks who don't know what an MDL, it's a multi-district litigation where you've got all these cases that are coalesced, and then the judge will make certain determinations, and it may have an impact on all of those cases. One court, one judge, might be thousands of cases. And then you can opt out and you can do different things, try your own case, that type of thing. But that's generally what it is. But here are the complications that I see with MDL and class certification. The coverage trigger, first of all, states define direct physical loss or damage differently. Different states do them differently. They interpret the exclusions differently. In different states, one party might have the burden of proving that it comes with, like the insured in Florida, all they got to prove is that they suffered direct physical loss of or damage to the property during the policy period. And then the burden of proof shifts to the insurance company to prove it's excluded. And then it shifts back. It's a shifting burden of proof, shifts back to the insured to prove the amount of damages. Other states, the whole burden of proof is on the insured to prove breach of contract, including their causation and damages. And so we have these different burdens of proof. One, or that's two. Next, you've got different tools of interpretation. So in one state, you might have something called reasonable expectation test, where the courts will look at the reasonable expectation of an insured in interpreting the policies. Other states reject that in favor of reasonable interpretation. And then we get to various exclusions, and then it involves how are we going to interpret concurrent causes. Different states interpret concurrent causes differently, and a concurrent cause is just two or more causes coming together to produce a loss. For instance, you've got a civil authority issuing an order, and you've got people staying inside because of COVID. Those two things come together. Are those concurrent causes? States treat those differently. Or are those an efficient proximate cause, meaning they're dependent causes? Some states then allow something called an anti-concurring cause clause, some don't. All that to say, I don't think that's the type of thing that gets resolved well in an MDL or class certification. We had the option. I filed our suits as individual cases.
Thank you.
All right, Josh. Does that make sense to you?
Yes, thank you very much.
All right. I hate to get in the weeds for everybody, but if you can't tell, I'm kind of enthusiastic about this type of thing. When we start talking about concurrent cause and efficient proximate cause, I get really excited. All right, who else do we got, Ned?
Hey, so Mark, we're going to do a last call for questions here. We don't have anyone with their hand raised, so last call for questions, everybody. Click the button to raise your hand if you'd like to ask Mark a question. Oh, here we go. We have Chris. 1 second. Chris, you're on.
Hey, thank you. Hey, Mark, how are you?
I'm doing well, Chris. How are you?
Fantastic. Thank you. Thank you for putting this on. Hey, question. So like I know with actual property loss or roof loss or something like that from a storm, insurance, the proof or the burden of proof is on the carrier to say, well, that didn't happen because of the storm. How does it work with these business loss policies? Like when you gave her the example of, hey, please help me, please investigate this. Where does that burden of proof fall for these losses? Is it on the insurance company to say once the claims are made, they have to prove that it didn't happen? How does that work?
So the insurance company has a duty to adjust the claim. The adjustment, every premium dollar that is paid, part of that premium goes towards the insurance company hiring people to perform an adjustment. An adjustment means that they are supposed to determine the cause of the loss and determine if those losses are covered, determine if there's an exclusion, and if they're covered and with no exclusion, determine the amount of the loss. That's what their job is. That's what they were paid to do with those premium dollars. At least part of every dollar goes towards that. So initially, they have that burden of proof. You don't have to prove the loss is covered. You got to prove you've sustained loss. You present the claim and you say, I've got loss. They then go and determine whether or not it's covered or excluded. Now, really, the next question is, who has the particular burdens of proof in, oh wait, let me see this, close this so you can see me. I realized I was looking at the chat box here. Everyone's asking some good questions. Here we go. So in court, generally speaking, the insured is going to have the burden of proving that there is a loss that comes, that occurs during the policy period. And so that fight is going to be on this direct physical loss of issue. The insured may have the burden of proving that. That issue will probably get resolved by the court during summary judgment. Once we get past that, then it would be the insurance company's burden to prove it's excluded. Otherwise, it's paid. And then the insurer person has to prove the amount of their damages. Chris, does that answer your question?
Yes, it does. Again, I appreciate it.
All right, thank you.
So Mark,
All right.
we have one more question. This will be the last question from James.
Okay.
And here we go. James, you're on.
Thank you. And Mark, thank you very much for this meeting. We are a network of contractors that does repair work and restoration work, mainly for insurance companies and other entities. We're getting ready through the carriers. The insurance companies are asking us to do COVID-19 cleaning, and some of the other clients that we have, like Race Gas Station, is asking us to come by and do some cleaning. And of course, there's the two types of cleaning would be obviously will be sanitizing, and the other will be also cleaning because someone employee may have had or been diagnosed with COVID, so they want us to come and clean. The others just want their store to be sanitized. What type of danger are we in if we are cleaning, let's say, our national contract with Racetrack Gas Station across the U.S., we're cleaning it, and let's say an employee 2 weeks later says they have COVID after our cleaning. What type of danger are we in because of something like that could possibly happen?
That is a great question. And I've talked to a lot of people about this issue. And so there is an exposure. And so step one, anytime you have an exposure, is to make sure you have good insurance on that issue. And so here's what the next call you need to make tomorrow would be to your insurance agent. And you need to make sure that your liability coverage covers this. If somebody were to bring a claim against you because they say you didn't clean it properly and somebody got sick or died, does my liability insurance cover that? And get it in writing. 2, are there any exclusions that apply? What if you had think about this. What if your liability policy has one of these exclusions that they're saying is a virus exclusion? And here you are, your whole job is to go clean and make sure that the virus is destroyed, eliminated. And then they say, oh, by the way, that premium you've been paying to us, thank you for that. But there's an exclusion in your policy for the very thing that you do. So you need to get it in writing from your agent that there is coverage for that and that there is no exclusion. And don't let them waffle on it. Confirm it in an email. You have told me that there is coverage for this and that there is no exclusion. We put it in an email. We, as you know, we clean buildings, businesses, and try to destroy and eliminate COVID exposure to people. If one of those people brings a claim against us, you've told us that we have liability coverage for that and that there is no exclusion for that. Thank you. And you see what the email comes back. If they say, hold on a minute, we didn't tell you that, then you need to go make sure you get a different agent and make sure you have coverage. Does that make sense?
Yes, it does. Thank you very much.
All right, and do your work well and stay safe.
Thank you, sir. Same to you.
All right, Ned.
Mark, I think that's it.
All right, everybody. Appreciate
Hey,
you.
Mark, can
Yeah.
I ask a quick question? So I think it's double-sided on what you were just talking about it, because let's say you got the employee, okay? So now you got a workers' comp claim. So will the comp carrier cover you, okay? And then if you have a client, then you have a liability claim. So it could cut both ways. So just thinking about that, I like your advice about calling the carrier. Many of them already said, no, we don't cover it, but everybody's thinking about it because of, concerns about that. The other thing was there's been some talk about the feds backstopping the insurance carriers so that claims like these for a business interruption could now be covered. That would be huge.
Yeah. Here's my thoughts on that. We'll see it. Here's what people have routinely said to me, well, what if they do now what they did after 9/11 and require that the insurance companies pay these claims? I say, well, stop right there. That's not what happened. What happened after 9/11 is the insurance companies were denying the claims, saying, look, this is an act of war. We have an exclusion for any loss or injury resulting from an act of war, no coverage. The government came out and said it's not an act of war, it's an act of terrorism.
Right.
And by the way, that's not excluded. What happened essentially the next day is insurance companies said, well, fine, we now have terrorism exclusions in our policy. You got to buy it.
Right.
And so I don't think that the government, either state or federal, is going to come in and mandate that insurance companies pay claims in violation of the terms of their policies. If it's excluded, then the government's not going to be able to come in and say, hey, you got to cover that.
Right.
The court might say that exclusion doesn't apply, but the government won't be able to do that. And so that gets us to the next question is, will a state or federal legislature say, if you pay the claims, we'll backstop you when your claims reach a certain level? Maybe. Now, I would parse those out, and I would suspect any legislation would say, hey, if there's an exclusion and you're not paying based on the exclusion, we're not going to make you pay. Right. But if the payment is made on a policy with no exclusion, once you hit a certain level of claims, based on your market share, we'll pay you X. I don't know if that gets passed or not, because I don't know how they would ever determine whether or not, or the cost of that legislation. So you've always got to determine and put forward, this legislation is expected to cost us X. That's going to be a whole lot of money. And I don't know if they know what that amount is. Does that answer your question?
It's a big number. It's a big number. Yeah. And so on the comp side, we've talked to the drug testing agencies, and they're like, oh yeah, we'll test all your people before they go back to work. But it's really useless to spend $150 to get them tested, because 5 minutes after you're done testing them, they could go home and their wife could give it to them, or the next person they come in contact with at the office could give it to them. So they're saying the temperature thing is a better thing to do. I don't know. It's nuts. There's nobody knows what to do next.
Right. How often would you test as the employer? I'm not sure.
Well, everybody's saying give them the temperature gun when they show up for work. You fail that, go home. But the comp is a question also, though, because you guys are involved with that stuff too, and we those are uncharted territories.
Right. Then you'd have to prove it's a workplace injury, and
right. And where did you get it? And
it can be done. I mean, once you trace it back, it can be done.
Yeah.
I don't know that that's going to happen a lot, though.
Yeah.
All right. Appreciate it.
Great stuff, though. Thank you.
Thank you. All right, Ned, anything else, or are we done?
We're good. Watch out for the email, everybody.
Yep. All right, everybody, thanks for attending. We'll have more of these. As the law develops and as things happen, we're certainly going to have more of these. And you will get the email. Look for the tool, we call Jimmy the Robot Lawyer, and pass that out to your friends, tenants, folks that who might benefit from that. And let's see if we can help them. All right. God bless everybody, and thank you.
Thank you.